Hello students, my name is Liz Attia and today's topic is the role of the expert witness. Okay, so the role of expert witnesses. So when there's an action at law, how does the court decide whether there's been a breach of duty of care? So remember, we actually said that one of the elements for a negligence claim is that there is first of all a duty of care, and then that there has been a breach of that duty. So the standard of the reasonable person in the position of the patient is considered. And the standards used in the profession are gleaned through expert testimony. So we do talk about the subjective standard in Australia, and it's in the position of the patient and what the patient would actually need to know, and what the profession or a body of peers would be considered would consider based on the subjective standard of what the patient would need to know would be reasonable given the circumstances. So the role of experts in those situations is to provide evidence or information to the court about what that standard would look like given the circumstances. So normally witnesses can only testify to facts which they know to be true. So, you know, if you're called to be a witness in a particular situation, it's about what you've actually seen, what you've heard, what you've actually seen transpire in your presence. And it's not about what your opinion is as to what's probably true. Now, that is all the case in terms of normal witnesses, but in terms of expert witnesses or expert testimony, the exception lies. So an exception to that principle of being a witness is that the expert evidence is admissible within the scope of expertise of that particular professional. So that professional doesn't need to have seen or heard or witnessed particular events. What they're actually talking about is what is reasonable and probable given the circumstances, as long as it's within their area of knowledge and professionalism and expert testimony. So expert evidence assists the judge or the jury to understand often technical matters which go beyond their level of expertise or knowledge. And you'll see it often in high controversial cases, and, case in point, I guess the Michael Jackson case, where they had other doctors actually provide expert testimony about what would have been the reasonable dosage, what should have been the monitoring protocols after administering the dose of medicine, etc., etc. So in our case, when we're talking about expert testimony within the health professions, it's about giving evidence, scientific evidence of which a judge and jury have no experience or knowledge. So it's telling them the nitty-gritty of the technical side of things that they might need to know. The expert's required to be objective and unbiased. Why? Because their primary responsibility is to the court. It's not to those who have actually commissioned their opinion. So I might be called as an expert testimony for the plaintiff. I might be called as an expert testimony to the defendant. But clearly my advice or opinion should actually be objective. Why? Because as an agent of the court, my first and foremost responsibility lies to the court in terms of the objectivity, and it's not just about who actually pays for my services. Now, having said that, clearly the plaintiff or the defendant are not going to put an expert witness up to say things that doesn't actually favour their side of the case. So it becomes a little bit of a moot point. Clearly, you'll only be commissioned to provide evidence if it serves the opinion or the argument that's actually being purported in court anyhow. Having said that, the expert testimony, the judge and the jury are not compelled to accept that. So it's to provide information to, but there's no obligation on the jury and no obligation on the judge to accept the expert testimony. So they can come up with their own conclusion in respect of the facts, and they're not compelled to actually accept the opinions being raised by the professionals. So it's to provide assistance, but there's no compulsion there. The code of conduct for expert witnesses actually tries to safeguard and ensure the objectivity of expert witnesses and impress upon them their obligation to the court in terms of objectivity rather than purchasing of opinion. So the code of conduct does need to actually be signed before expert witnesses will actually attest to the court, and that basically says that they understand that their obligations are to the court and they agree to be bound to that code of conduct. So, as I mentioned, expert witnesses must confirm their adherence to the code with a statement, such as, I have read the code of conduct for expert witnesses and acknowledge agreement to be bound by it as per the relevant district and Supreme Court rules. Thank you, students. That brings today's topic to an end.